Welcome to the program. My name is Marty Schenkman, and I'm joined by two great speakers on a really important topic. Just so you know, and I'll say it again in a minute, we have handout materials on the handout tab, and I'll go through some of the formalities in a second. So the topic we're going to talk about is a very recent CCA. I think it came out the last day or second to last day of last year, CCA 2021-52018, and it has some really significant implications, not only to GRATs, but to valuations in estate planning, and I think a number of other areas. So just some brief pointers before we get started. The PowerPoint is on the webinar on the console. If you click on the handout tab, you can then click download and download it and have it for your files. A copy of the handout will be posted to Schenkman Law on the blog page. You can get it there. After the program, we're going to post a recording of the entire webinar and the handout materials under the webinar tab, and there's a library there of, it's not 50, it's 150 webinars that you can access anytime. There's also a growing library of planning video clips, and I hope to entice my two co-speakers to do more of those on Law Easy. We do not give CLE or CPE, but we will generate a attendance certificate for those that can use it. The certificate is generated automatically. We can't do anything about regenerating it if there is any issue with it, so forgive us in advance for that. If you have any questions, the panelists' email addresses are at the end. Better to email us individually so we can get back to you in time rather than posting it to the webinar formality. The webinar console. We have three people for some quick comments as sponsors, and then I'm going to let Jonathan, who doesn't need an introduction, introduce our third speaker, Scott, who also doesn't need an introduction, but we're going to give him one anyhow. So first sponsor, Vanessa, can you tell everyone about ILS?
Absolutely. Thank you, Marty. It's our first, I believe, our first co-sponsored webinar with you this year. I'm very excited to kick off another great fruitful year of webinars with you. Welcome everyone. Thank you for attending. My name is Vanessa Kanega. I'm the CEO of Interactive Legal. If you're not familiar with Interactive Legal, we provide automated drafting systems and other educational and other resources for estate planning and elder law attorneys. Our systems include forms for many circumstances, including your typical estate plan, and more complex planning like GRATs, which our panel is going to be talking about today. We also have the library of Schenkman, ILS, and Peak sponsored webinars available on our website at interactivelegal.com. So visit us and contact us if you have any questions or you'd like more information. Thank you.
Thanks, Vanessa. And our second sponsor is Peak Trust. Nicole?
Yeah, welcome everyone, and thank you for attending today's webinar. My name is Nicole King, and I'm a trust officer here at Peak Trust. And we're pleased and honored to be able to sponsor or co-sponsor today's presentation. Peak offers a full spectrum of trustee services. We service individuals, families, and their trusted advisors, and we offer flexible and customized administrative services for all types of trusts, including GRATs. So I invite you to visit our newly designed website at peaktrust.com, and if you should have any questions, feel free to reach out to myself or any member of the team, and enjoy the webinar. Thank you, Marty.
I'll give an additional plug for Peak. I sent Peak trusts and transactions probably almost up to New Year's Eve, it seemed, last year, made completely unreasonable requests of them. And not only did they meet every unreasonable, untimely request that I made for clients trying to get stuff done at the end of the year, but they did it with a smile and they did a great job. So much appreciated. One of the things that I've tried to do on as many webinars as possible is to feature a different charity. We all have clients that can benefit from and benefit charities with their charitable giving, and I think it's a wonderful opportunity to introduce different charities to you on different programs. And today we have the honor of introducing really one of the most amazing charities. Veronique, can you tell us a little about the Fox Foundation?
Yeah, thank you so much. So the Michael J. Fox Foundation is the largest private nonprofit funder of Parkinson's research. We started about 20 years ago and thought, what can we do to accelerate research funding so people can get new treatments and cures faster? And in the 20 years that we've been here, we have been part of being able to shorten the timeline for new therapies from around 27 years to around 12 years. That still feels too long if you're living with a disease, but collaboration and innovation are happening, and the therapeutic development pipeline has never been more robust. In the last 7 years, we saw 17 new therapies, and many therapies are in clinical trials with the potential to be curative. We use an innovative and collaborative approach. We try and have all of the players in the field working together and to fill any gaps where we can. Such as coming up with ways to measure potential cures so that they can all reach the finish line at the same time. There's a lot going on. We funded 3,000 projects. There are 700 in clinical trials right now. Over $1 billion has been funded since we began, and we truly are encouraged by the promise that's happening within Parkinson's research and progressive development, progressive neurological disorders. So let us know if you want to know more, or if you have clients that are interested in finding out what is encouraging in the research field. Thanks so much.
The Fox Foundation is a uniquely amazing institution. If you've never worked with them, I encourage you to directly, just to do a good deed or on behalf of clients or loved ones or others that may have Parkinson's. But even beyond that, some of the groundbreaking research that they've funded has really been incredibly important to brain disease generally. And you know, kudos to them for always being so professional and doing such an amazing job. So now let's jump into it. So I'm going to kind of set the table quickly. Jonathan and Scott, after Jonathan first introduces Scott, are going to interrupt me on a regular basis. But then what I'm going to do is that after sort of brief segments where I talk about something from the CCA, I'm going to open it up for discussion between Jonathan and Scott, an impromptu, off-the-cuff discussion, because there's so many interesting issues to talk about, and I'm really looking forward to hearing some of the interactions. And just in preparing for this, Jonathan and I were speaking earlier in the day, and have a couple of interesting insights that I certainly hadn't thought of before we started chatting about it. So hopefully we'll give you some very interesting ideas. Most important point, and then I'm going to have Jonathan introduce Scott, the ramifications of this CCA, I think, go well beyond just the facts in the case and what's going on. So I think this really is important for a lot of advisors, not just estate planning attorneys and not just people doing GRATs. So listen on and we'll do that. Jonathan, I think everyone knows Empire, but introduce Scott so that we can give him the courtesy of a formal introduction.
Well, I've worked with Scott and his company for about 25 years. I've used them extensively, and I could say I've had great luck with them, but they do such a professional job that I rarely have had the Internal Revenue Service make a real challenge to their valuation. They are conservative, which I like, and again, I've had great fortune in using them as my appraisers. Also, they're very, very helpful in giving practical advice on things, part of which we're going to go through today. Back to you, Marty.
And I can second that motion. I've worked with Empire for a very long time, and the only thing I would add, they're also a pleasure to work with. So let's get started. So the CCA was issued December 30th. And
thank you for that.
You're welcome. And Jonathan wanted to make sure that I noted that even as the CCA says, it can't be used or cited as precedent, but certainly it could be very instructive, and I think it is. It addresses a common valuation challenge. Everybody on this call has this happen many a time in practice. I would be surprised if we each don't see this several times in a year. Client on the far end of the spectrum, nothing's going on in terms of selling their business. They're not even thinking about selling the business. On the far end of the spectrum, on the other side, they've sold the business or have a binding contract that no one can get out of. There's an awful lot of ground of in between. And that in between is where some of the issues arose in this case, and we're going to talk about it. And I'm going to ask Scott as we go through the program to elaborate not just on the facts in the case, but to give us some insight on that spectrum in general, because we all see this issue. So a client started talking to somebody. How far does it have to go? We're going to talk about all of that. Big continuum, lots of spots on the continuum. In the CCA, the IRS held that the transaction, whether it's a merger sale, doesn't really matter, had moved so far that it was inappropriate to ignore it in the valuation. And we're going to talk about that and how appraisers may want to deal with this, which is something that accountants and attorneys and anyone involved in estate planning needs to understand, because this could be the Achilles heel of many transactions. Now, what the IRS did, and I'm going to ask Jonathan when we get there in a few minutes to elaborate, because it's a very important point. The IRS applied the reasoning in an older case called Atkinson, which many of you may remember from the CRT area, and held that the valuation was so wrong that the GRAT annuity that was paid was not qualified and blew everything up. So we need to talk about Atkinson, how it was applied in the CCA, how it may apply in a broader context, and we're going to speculate as to how this may affect planning generally. Now, it's important to note that Atkinson had nothing to do with valuations, but it had to deal with proper administration of a CRT. And we're going to talk about that because that too may have some very interesting implications as to where the IRS may be going on audits. So keep in mind what this now means, and the numbers, according to the case, were as in any private letter ruling CCA are blotted out, but they did say the word billions. So there's an awful lot of money at stake here. If the GRAT annuity failed and it was a near zeroed out or zeroed out GRAT, that means that the gift amount was the full value of the property. So there could be an incredibly costly gift tax due as a result of that. We're going to talk about what this may mean to GRAT planning. And there's some ripple effects to GRAT planning that may not be obvious that we're going to talk about, such as in spillover mechanisms and what it means in using a GRAT as a defined value mechanism. We'll explain how that works for those that don't recall, but we're going to really focus in on technically what that may mean to how you structure a defined value clause. What does the CCA mean to valuations generally? I mean, at minimum, when we go through this, it's a wake-up call to be very careful, more careful perhaps, about transactions and process and how they're handled. What kind of precautions and steps might practitioners want to take? I can tell you that I've already taken steps in my practice to apprise clients doing transactions of these issues. So that's what we're going to go through. The last point on slide 11 was something that Jonathan and I kind of pondered just a few hours ago preparing. There was a case, and we did a whole webinar on it, and it's on the Peak Interactive and on the Schenkman Law websites, if you didn't see it and want to, called Smaldino, and I've given you the citation. In Smaldino, some people kind of just talk about it as a bad fact case that dealt with step transactions, but it was really, in my view, a case that dealt with administration and implementation of a plan. And there were a lot of failures, and the taxpayer got slammed for them. But if you take a look at Smaldino and then you consider Atkinson, both, which was discussed in the CCA, both cases focus on administration. So, we all have to really think, is this a signal where the IRS may be going in terms of its audit approach? Are they going to focus more efforts on administration? Lots of clients don't want to come back to any of their advisors. They may do the best plan with the best documents, and I never use the word best, but just for illustration, the best plan, the best documents, but if it's not administered properly, the IRS may not have to go to the mats arguing about complex legalities, technicalities, and whether the technique itself worked if it wasn't administered right. And this could be an important window into where we're going. So let's talk about the facts in the case, and I'm going to paraphrase them because I think the real interest here is hearing Jonathan and Scott talk about what this really means. So Scott, the donor founded a very successful company. They had contacted investment advisors to find an outside buyer, and they were marketed through investment bankers. And there were meetings and things scheduled, and there was a clear expression of interest. Potential buyers were expected to purchase a minority stake in the company and then have call options to buy more of the company later under some kind of formula. just in general, before we dig deep into the CCA, what is the impact of these kind of discussions on the appraisal process, and what might you suggest people do to deal with it?
Yeah, it's a very good question in a situation, and like you said, we deal with it quite often, and at both ends of the spectrum. And I don't mean to take it to no one's considering anything, but to a situation starting here to points where they've signed the agreement itself, and it's just a matter of time before they finish due diligence and close and even do announcements. So this definitely, in my book, should have been brought to light to the appraiser if this was going on at the time. And then the appraiser can, and especially if they're moving this far forward, the appraiser has to deal with it. There's a lot of ways to deal with this kind of stuff, whether it's just to discuss it and look at the likelihood of something happening and accounting for it in some way that's appropriate to where it is. But it should be dealt with, I think. When somebody asks, or somebody, and I always tell clients, tell me what's going on. Don't hold back. Anything that might change, especially related to a sale or anything like that, because there's nothing worse than being in exactly the position that this appraiser was in, where you do a report and then something happens shortly thereafter that they should have told you about, and it makes your report not only misleading, but it's misleading to the client, because ultimately they're going to have a much bigger problem with it because the report is really not relevant. So you open the door to the IRS bringing in, if the disagreement is large enough, bringing in their own appraiser who may well be biased if it's on the other side, on the high side, and why even allow for that? Anyway, there you go.
So
Scott, this is Jonathan. Do appraisers, when they're asked to appraise a company or an interest in a company, does the appraiser typically ask whether or not there are ongoing negotiations about the sale of the company or part of the sale?
I would think that good quality appraisers should and do. I think it would be somewhat remiss. I know we always do. It's I think important. I mean, if I'm playing in the role of a willing buyer and or a willing seller, those are that's information I want to ask about, and as the appraiser, I would ask, and they should be.
Yeah, I very often, when I would have an audit of an estate, for example, one of the questions the IRS estate tax attorney asks is, have you sold anything? No, nothing's been sold. Well, have you put it up for sale? Do you have it with a broker? Have you gotten any offers? And you just can't, hide behind, well, we've had a few tire kickers, because they will ask who those people are. So, the most important thing when you're going to an appraiser is don't hide the ball. Be open. There may be some things that you can do to discount it, because, very often people will make an inquiry, but they aren't really serious about it. And it's better to get it on the table at the time of the appraisal rather than at the time of an audit.
Yep, and a lot of clients get regular, in good times, get regular, letters and calls from business brokers about their business, and that's kind of, standard operating procedure. So those don't make any difference to anybody. It's when you get to hiring a banker and doing things that it becomes something to be considered.
one of the practical problems is clients that are doing a planning transaction, an estate planning transaction, they don't want to really discuss and disclose what the facts are. So they try to downplay it, poo-poo it, and avoid even bringing it up. And I think that was part of the downfall the taxpayer faced in the CCA. Had it been disclosed and had the appraiser had plausible explanations, and this is something we can talk about now or later, Scott, as to why it wasn't the potential sale price that equaled the fair value. then they still may get some of the if you will, leverage on the valuation. You know, the fact that there's been discussions doesn't cement a deal, and there may be nothing guaranteeing a deal happens. And we've all had lots of clients who've gotten letters of understanding, signed NDS non-disclosure, you know, NDAs non-disclosure agreements, and nothing happens. So, you know, the fact that there's something in existence doesn't mean it's an assured thing. But it almost seems to me, and Jonathan and Scott, I didn't talk about this in the PowerPoint, maybe you can comment. It almost seems to me that had the appraiser been informed and had the client permitted the appraiser to update the report, they may have been able to justify a lesser value because of the uncertainties in anything closing, because I don't think anything was signed at the time the GRAT was funded. I think a lot of clients also, and this is a real practical issue, don't want to spend the money to get a follow-up appraisal. I think it was different in this case, and we're going to talk about it. Any comments, Scott, on how you evaluate the likelihood of a deal closing? You know, if there's just an inquiry or an NDA signed, does that really cement anything?
Yeah, I mean, if I mean, we would probably talk about it in the appraisal, that, you know, there was some discussions, but if it's only an NDA and there's no bankers or anything, you know, or maybe it's you know, they're thinking about that, I think it would be, we talk about it, that it might happen. It's more when it gets further along that we start to kind of introduce an analysis that says, you know, here's a potential sale scenario and here's a potential non-sale scenario, and sort of working, you know, probabilities as to whether something, and discussing what, you know, why you might put a certain probability for sale or not, you know, sale. So we work to reasonably reflect the risk of a sale, and then, you know, then it becomes more a question of what is a potential sale price, and you know, at the point that the fellow made the transaction, I mean, they had some pretty solid numbers and some pretty solid offers, and you know, he assumed he could use a very outdated, you know, appraisal. So, you know, it's really, I come back to a facts and circumstances kind of situation as to how, at what point do you go from, hey, you know, they're sort of thinking they might do something in the next year or two, to they've started and they're active and they're proceeding, you know, in that vein. And then you got to change your strategy, and you have to change your approach to considering a sale.
Yeah, well, let me make 2 points here. Number one, Scott knows that I do this. Someone will have an appraisal done, whether it's by Empire or someone else, and then 2 months, 6 months, 10 months later, they want to now do the deal, and they say to me, I can use that prior appraisal, can I? And I say, no, you can't. You're going to have an appraisal done as of the date of the transaction, whether you're putting it into a GRAT, a charitable lead trust, making a gift, whatever it is, and you have to get an updated letter. Now, Scott might come back and say, we, you know, look at it, it's the same, nothing significant happened, so we're sticking with the valuation we gave you 6 months ago. The second thing, which didn't come up in this CCA, and you really need to worry about it for these people, if their position is sustained in the court, I guarantee the IRS will propose undervaluation penalties. Remember, it's not that 1% or 0.1% or a tiny, tiny gift that was made. They're taking the position that it just didn't qualify as a GRAT, and therefore it was 100% a taxable gift. And they'll say that because you misvalued on your return, we're going to impose a valuation and undervaluation penalty, which can be extremely high. It can be up to 40% of the amount of tax due, and it's non-deductible. So, you know, you've got to really get your clients to a position where they tell everything is disclosed. And that way you're going to be safe, because I'm going to guarantee the IRS is going to say you couldn't rely on this appraisal because you didn't follow the rules, and therefore there is no justification for using that valuation. So in addition to the tax, in addition to the interest, we're hitting you with a great big valuation penalty to boot.
So Scott, let me ask you a question. Just because the appraisal is 7 months old, if there was nothing going on, if there were no offers, no discussions, that in itself wouldn't necessarily make the prior appraisal invalid, would it?
I tend to think that it's pretty stale, and it's not really self-serving. But I mean, I'm trying to make sure that the client doesn't, get into trouble. To me, if something's 2 or 3 months old, okay, and if nothing has changed, that to me is fine. But 7, 8 months for a business appraisal starts to get old, and the appraiser that did it, there shouldn't be all that much of a cost. I mean, I think it's money well spent to roll the thing forward and to a date that's much closer to the actual transaction date. I think it's money well spent. But, we have had situations where somebody will ask for kind of a roll forward. So maybe our appraisal is 2 months old, and they want to have a letter rolling the valuation date forward that says that, let's confirm that the appraisal is reasonable. And, we do those as well. But we actually go into the market, we check comps, market comps, we talk to the company, we spend time in making sure that nothing has changed that's material before we execute that kind of a letter. And because it's not to be taken lightly, because if you do a deal on that and nobody did any work on it, it's kind of a useless letter.
Yeah, I think the challenge we all face as practitioners is clients don't want to spend the money, they don't want to spend the time, they don't want to deal with it, but then they really have to understand and accept the risk of what happened in the CCA in whatever context of the type of plan that they have. But this is something every practitioner has seen.
Right. Oh yeah, and we see it with real estate all the time. People will come to us and they've got a 9-month-old real estate appraisal, and we're asked to rely on it. But I mean, we're as an appraiser and as the people that are going to be signing a tax return, to say that these are reliable. That's something that we all as practitioners want to make sure that we're not skirting the facts in that case. So it applies to all of us as well.
So just a couple of quick comments. Part of what I think concerned the IRS here is it looks like they got 5 different offers, 5 offers presented to them by the investment bankers, and 3 days later they funded the GRAT. So 5 offers is not like one kind of chit chat discussion. It sounds like, we don't have more details, but it sounds like there was some pretty meaningful activity, and maybe the client said, gee, I better do this immediately because otherwise I'm going to have that value. And 3 days later they did the GRAT. My guess, and I may be wrong, is the client was kind of relying on, well, the GRAT has this automatic valuation adjustment. So long as you denominate the annuity as a percentage of the fair value of the asset, if the IRS comes in, I don't really have any downside risk. I think, Jonathan, you may have a different take on it, but I kind of think the taxpayer was being aggressive and relying on the automatic regulatory GRAT adjustment mechanism and feeling they didn't have a downside. But it turned out they had a big downside.
Marty, I agree with you. In fact, with Diana Zadel, I wrote an extensive article back in 2007, and we had it republished a number of times, comparing GRATs to other strategies, for example, installment sales to Grantor Trust. And one of the things that people tell me, well, you don't have to worry about anything going wrong with a GRAT because it's got this self-adjusting amount for the annuity. And that this shows that's just not going to be true. The IRS has now staked this out. And I think, Marty, you said it first to me, this may be the way they're going to go after money. There's not much they can do with respect to a GRAT. But if they can come in and say, we're going to disregard it because it was improperly administered, because the annuity was so different, so much lower than what it should have been, then you're going to find out that there really is a serious problem with the GRAT.
So I think, and we're going to talk about this more as we go through the program, but we need to reevaluate the perception that some had that a GRAT was like a safe bet because, gee, it has an automatic valuation adjustment mechanism built right into the regulations. Now, that's not a guarantee anymore. Scott, what makes an appraisal stale? I mean, you gave some indications. Are there any factors other than an obvious sale that might practitioners might be alert to caution clients about, or to make sure the appraisers are informed of? What do I do to make sure that if a client's doing a deal and you're doing the appraisal, that we don't have a stale appraisal?
Well, you know, obviously it's going to make a difference as to whether you've got an investment holding company and you're talking about assets that it might hold, that some being marketable, some being illiquid, where those kind of date differences don't work at all, versus an operating company. So you can have changes, you know, somebody might gain or lose major customers, and so the outlook looks, you know, much different. You might have a change in the marketplace. There's anything that materially changes the outlook that was part of the appraisal process, that was determined to be a reasonable outlook, part of the appraisal process, can lead to an appraisal being stale. And, you know, it's well worth going back to that appraiser and asking them, you know, having them make the determination, is this thing stale or not? Because you know, the typical practitioner might listen to the client who says, you know, no, it's not stale, everything's the same, but impacts on value might not be the, you know, thing that a practitioner would see or understand. So I think it's best to go back to the appraiser and ask them.
Keep in mind two things. The name of the game in estate tax planning is valuation. That's it. That's the number one thing. And the IRS collects more money on changes in valuation than all of the legal issues combined. Now you might say, well, this is kind of a mixed a matter of valuation and the law, but the IRS doesn't make an awful lot of money in attacking things that they don't work under the law. It didn't qualify for the marital deduction, didn't qualify for the annual exclusion. It's always valuation where the big money comes in. I mean, that's where, you know, the IRS is really hungry for money. It really wants it, and it gets it by changes in valuation. That's why if you have a zeroed out estate because of the marital deduction, it's as rare as hen's teeth to get an audit for that. Why? There's no money in it. But give them something that they can argue about valuation, a piece of art, a business, a piece of land, and you're going to see the IRS in there claiming that you grossly undervalued it, and they want, you know, a pound of flesh. Having a good appraisal, and I'm going to tell you, I know this because, you know, I've done this hundreds of times. Getting a good, solid appraisal where you have not hidden the ball at all from the appraiser, the appraiser's recited anything that should be known, is the best thing you can do to protect your clients.
Scott, let me ask you a question, and it's a little unfair, and I know the answer may sound self-serving, but one of the things that's concerned me, some clients will respond, you know, my accountant will prepare the appraisal. Does it make sense to have the accounting firm that's doing the tax returns and the, you know, the audit for the client to do an appraisal? What's the issue with that?
Well, first of all, you want to make sure that the accounting firm that you're talking about has the qualifications to do good appraisals, because there's plenty of big accounting firms out there that do have good appraisers and do good quality work. Regarding if you're talking, a lot of audit firms don't like to do tax gifts for audit clients. I mean, it's sort of, even though they can, they tend not to like to do that. I tend to view it as sort of a conflict of interest. If someone wants to point at something related to an appraisal that appears like they've taken, multiple steps to reduce the value versus maintain a more neutral stance, the fact that it's the audit firm or the tax preparation firm, I think just adds credence to the concern that the thing was swayed by a customer that was a much bigger client on the audit side, and they did this work for them for as a courtesy, and they had sway on it. There's plenty of small accounting firms that don't know what they're really doing, and I think in terms, and I'm not going to knock the big firms because some of them do very good work, and some of them refer work to us too. Because they don't want that conflict of interest to be thrown in their face. So,
I've seen, as you say, Scott, some of the bigger firms actually tell the client it's not appropriate for us to do the appraisal. Get somebody independent. We'll even recommend somebody if you want, but we shouldn't do it. But that's just something that clients and practitioners should keep in mind. Now, here's one. Let me just say what happened, Scott, and I'm going to throw it back to you again. So one of the things that was done is the appraisal that was used was done for a deferred comp plan under Section 409A. So I guess one of the questions is, and forgive me if I'm putting you on the spot, I hope, I don't know the difference, but is a 409A appraisal sufficient for gift tax purposes? Is the definition of fair market value the same? Is the data that's included in the appraisal the same? Do you know?
I'm not an expert in the differences, but I certainly have some thoughts on it. The 409A is usually states that it's not to be used for any other purpose, and it's only for income tax reporting purposes, for setting a stock price, for options typically. So you can, and those things typically will get audited, and if it's a bigger firm, they'll get audited by big firms, by an audit firm that's a larger firm. And we do 409A work internally as well. We wouldn't do a 409A style appraisal for this for a couple of reasons. One, big audit firms have a tendency to say, I don't like anything more than a 20% lack of marketability on this because the various regulators of our business don't like that. So we're gonna say, we don't buy that there's a 30% lack of marketability, or we don't buy some of the discounts that we as independent appraisers firmly believe are out there if you're ever trying to sell a small non-marketable piece of a business. So the discounts typically get mitigated. I'm not sure that the folks that do those want to necessarily have to defend them in any kind of a audit situation. And there's not a lot there. Another thought on it is there's not a lot of oversight on these things. I mean, they tend to get done. The CFO sticks them in a file, and they never see the light of day, until they do some kind of a IPO, and then they have to go back and redo them anyway. We get called by the big firms to go redo, the 409As, historically, because some of them get way out of hand. And I've dealt with a number of them, and some of them have outrageous values. I mean, it's surprising. You'd think that the bias would be downward if they're going to set option prices for for their management. I mean, I've seen stuff where they accept management's projections and they discount them at way below risk rates for what the risk in those projections are. And a $400 million company, that's really a $200 million or a $100 million company somehow, gets used for a gift tax. Now I don't know that happens in every case, but certainly some of the stuff I've seen they're usually higher than lower than what they should be. So I don't know if that.
You'll notice here that at the very end we have a cite to Reg 301-6501C-1F. That's the regulation that the IRS says you have to disclose if you were taking the position that there was no gift in the transaction. So, for example, if you sell something to a grantor trust and you want to be sure that you get the statute of limitations going, and you say, but it was a full value sale, if you want the statute to run, you have to make a disclosure. And everything you see in a 409A appraisal is not going to necessarily cover everything that needs to be disclosed to get the statute of limitations running for gift tax purposes. That reg 6501C is for estate and gift tax purposes. It's not for income tax purposes. So you get this appraisal and whoever did it says, oh, it's a wonderful appraisal. I've never done a better one in my entire life. It's just perfect in every way. And you attach that when you claim that that's the gift tax value. If you don't disclose everything that Reg 301-6501C-1F requires, you haven't made an adequate disclosure, which means the statute of limitations never begins to run for gift tax purposes. So don't just rely on an income tax appraisal, whether it's 409A or whatever it is, because you're not going to hit all the stops that regulation requires in order to get the statute of limitations running.
I think that's such an important point. Let me just stress, there's then two issues. First, is a 409A or any other appraisal that's not done specifically for gift tax purposes the right value? But secondly, just as important, will you meet the adequate disclosure requirements if you put that appraisal with nothing more on the return as an exhibit? And if the answer is not an affirmative yes, you're not tolling the statute of limitations, the audit period never ends. So people need to be really careful, clients in particular. You know, I got an appraisal for a bank, I got an appraisal for this, and they want to use it to save the money at their own peril. Now, one of the things that happened in this case, and then I'll ask both of you to comment, and you know, this should have been obviously an issue to the client, and I think it suggests that the client was being perhaps a little too aggressive. So they used a 7-month-old appraisal to value the company because that old appraisal didn't reflect the potential sale. But then when they were later doing a charitable remainder trust, where unlike the GRAT where you want the lowest appraisal possible, for the CRT you obviously want the highest appraisal because you want to maximize your charitable contribution deduction. Well, golly, they used a different appraisal that was at pretty much the sale price. So now they have, within a fairly short number of months, you know, time period, one appraisal on the low end that ignored the sale and the other appraisal on the high end, and gee, they used the appraisals that gave them the best tax result. I mean, it seems to me that inconsistency, because there was information known at both ends, that alone really sort of incurred the ire of the IRS. Scott, Jonathan, comments?
Really bad facts.
Yeah.
That's terrible approach to that's a bell ringer.
And to me, this is not a highly technical issue. This is something that any wealthy client should understand. You're undervaluing here, you're valuing a top dollar here, and you're doing it within a reasonably short period of time. How can anybody, just based on common sense, forgetting technical knowledge, why wouldn't they understand that inconsistency itself would set them up for greater risk? It just seems very problematic. And I think the broader lesson of this is anytime clients are doing anything where there's an inconsistency in the arguments or the positions, they need to be wary. It's inviting, potential problems. I think we've kind of covered this. So let's go on. So we've talked about the facts, and we've used those as sort of a springboard to talk about the implications to planning. Now let's talk about some of the law that the CCA discussed. And I think for this segment, it's going to be Jonathan commenting before Scott, and maybe without Scott. But Scott, don't be shy to jump in. So what is fair market value? And maybe, Jonathan, you want to comment first. What is fair market value for gift tax purposes? You have to have this hypothetical buyer and seller with reasonable knowledge of the relevant facts. What are the relevant facts, Jonathan?
Well, that's it, Marty. It's, the price at which the property would trade hands between a willing buyer and a willing seller, both having reasonable knowledge of relevant facts. I mean, they neither may know that there's oil in the ground or there's gold or something like that. You can't hide the ball. If you know something that would affect value, you have to say it. Whether it's good or whether it's bad, you have to, do it. And the buyer and seller cannot be acting under a compulsion. My father-in-law once bought some property, and he realized it was a ready-mix cement plant, and he realized that the driveway on it was too narrow. He had to expand it by 10 feet. He needed about maybe a tenth of an acre of land from the people who owned the woods there. And that, at that time, land might have sold for $500 an acre, and he just wanted not even a quarter of an acre. He wound up paying $25,000 to get that 10-foot thing. Why? Because he was acting under a compulsion. Now, that doesn't fix the value. And you can sometimes argue that people were acting under a compulsion, but don't count on it. If there's been a sale, unless you can show it's something extraordinary, like the guy that had the woods that sold a piece to my father-in-law, you can bet that his estate didn't put it down at $25,000 for a quarter of an acre. But normally you're not going to have people acting under a compulsion. Just because they want it or they want it badly, that's not going to be it.
Scott, what is the lawyer or the accountant's role when you're doing an appraisal to assist in getting facts? Do we have any role? Do you as the appraiser really get all the information? I mean, obviously, if one of the other professionals knows something, they should be, informing you of it. But is there anything we really need to do?
Well, again, it's a lot of facts and circumstances, but in some cases where there are situations where the lawyers have information, maybe it's a potential litigation coming down the pike, or maybe there is some litigation about an asset, and we do look for guidance from the attorneys with regard to some of the documents that might be unclear. We would expect that the practitioners, to the extent that they're trusted advisors and the like, that can help us understand what might be going on. We would expect and hope to get that kind of cooperation from them. So, does that answer your question?
Yeah. To me, one of the problems that may have been here, and again, as with every case, with every ruling, we don't often have the whole picture and the backstory to really know what happened. But one of the things that I've seen happen, it may have been part of the issue here in this case, the investment bankers are trying to get a deal done. They're really not particularly interested in spending time or distracting from getting the deal done by talking with an estate planner that is, almost a nuisance because they're trying to transfer assets they're trying to sell. And corporate counsel is often, especially on a large transaction or a transaction where the securities work, maybe a different firm than the estate planner. Are they really talking and picking up the phone or sending an email to the estate planner? Hey, just wanted to give you a heads up. We got a deal in the wings and we're drafting an NDA and a letter of intent. They don't often communicate the way perhaps the estate planning attorney, accountant, and appraiser may communicate. And that's really got to be on the clients to say to their other advisors, corporate counsel, investment bankers, et cetera, keep my estate planning attorney or my appraiser, whoever, fully apprised of what's going on. And that sometimes is part of the challenge. Hypothetical willing buyer and seller. So, Jonathan, any comments on what that means?
By the way, Marty,
it can't be a particular individual. It's got to be a hypothetical person. It's, kind of the test you use for reasonable cause? Was it reasonably foreseeable? You don't necessarily have to have an Einstein or have someone who's, hopelessly mentally challenged. It's kind of the average person. And here you're looking for what would this trade hands between a willing buyer, someone who wants to buy, and a willing seller. And, the best evidence, and this is used all the time, is what it's sold for within a reasonable period of time. And I've certainly had the IRS accept, when sometimes it's good, 1 year from the valuation date. Like, you sold a home. We sold it a year later. Readily accept that, even if it was lower than the appraised value on the 706 to begin with. On the other hand, if you sell it for more, you're no way are you going to convince them, except maybe for a slight change in market conditions, to accept a lower value. So you have something appraised, whether it's a work of art for $10 million and it winds up selling for 15, you're going to be stuck with 15. And I've had some people that I've said, look, let's not risk selling it now. Let's wait until the audit is over, because this may sell for a great premium because of the provenance of who owns it. Now, that in theory takes into account who is the willing seller. It's like Marty, as everyone knows, is a great painter of nudes. And when we go ahead and Marty finally goes to his reward, I'm going to insist that we not put those up for sale right away, because they'll sell at a great price. Marty keeps the market very small. So you've got to really watch out for that. If you're going to have a sale, understand, especially in light of this CCA, they're going to insist you use the sales price, and my guess is that they will insist upon a valuation penalty. And you can imagine how upset your client's going to be, not only because she has to pay more tax, but then she's hit with a penalty. So, I've done this, and they won't follow my advice, Marty. I send them a letter saying, I think you are making a mistake, because, we can no longer change the 706. We've already gotten it in. Now you're putting it up for sale, and if it sells for significantly more, you're going to be in a problem. Although I will say, in the audit, if you say, oh, by the way, but we put that work of art in there for 10 million, it turns out we sold it for 15, we think the proper value is 15. I've never had them come back and threaten a valuation penalty in that kind of case. So be open and be honest. Of course, with gift tax purposes, they don't usually do it. But as Marty has pointed out, how often do people get audited on GRATs? It's as rare as hen's teeth. But in light of this particular CCA, and remember, a CCA, although technically it can't be cited or used as precedent, it is much more powerful in the Internal Revenue Service than a private letter ruling is, because the chief counsel of the IRS has now written it. I've dealt with them. They're very, very bright, very informed people, a lot of experience. So this CCA, Marty, I think you're right about this. This is going to really be used by the IRS to go in and audit GRATs where they have been funded with non-marketable securities. So you can have a difference in valuation, and they're going to contend that you get zero value for what the grantor retained, which means the whole thing is subject to gift tax, and you also are facing massive penalties.
Scott, let me ask you a question. In this case, they used the actual buyer, but I believe, if I recall, in the language of the CCA itself, it spoke about the buyer being, all the buyers being strategic buyers. Had they had more time between the offers and the sales and hired an independent appraiser, maybe they would have had a lower value than the actual ultimate sale price, because the hypothetical buyer standard is not the strategic buyer. It's not the buyer looking to acquire a company to get a toehold in a new market, or to acquire a particular piece of property that was uniquely needed by them, like Jonathan's example with the road that had to be expanded. Any comments on how a value may differ from hypothetical versus strategic?
Well, a couple of things, and I'll maybe talk about one case. Here you had all strategic buyers coming to the table. So unfortunately, that's the market. you're sort of caught. That's the market. For whatever reason, the leverage buyout guys, or private equity, if you want to call them that, didn't come to the final round. So you're dealing with the buyers that make up the market. So that's a problem here. The case that I was thinking of that highlights, I think, maybe what you're talking about, although it has a nice time element as well, was a case that we did in Florida where there was a company and the main shareholder died, and in his will, he willed that the company be sold because his brother was a spendthrift kind of character. So he didn't want the company itself to be subject to, depletion by the brother or mismanagement. So they called us and they said, we've got all these, offers that have come in, and, we need a valuation for the estate. So we looked at probably 4 different offers, and they were all different, all complex. They started at like 32 million or whatever. And when you started to take them apart, which we did, because, offers there's a lot of aspects that impact the value of an offer. And we were concluding probably around 28 million. And we had all these offers right in this range. That to me is the market. But then along comes at the end of this process, there were some facts that came to light earlier that came to light later. But at the end of the process, there came a really strategically advantaged buyer that could reduce the cost related to the product by probably 50%. And they came in and they bid, we were in the 28 million, they bid 40 million. And, our analysis, we mentioned that there was this buyer out there, but they were unique and they were not a willing buyer, willing seller. And we also put a 15% discount on the probability of the transaction and the risk related to proceeds, because some buyers will use a lot of debt and you got other issues with burnouts and things like that. So, I think the report stood pretty well with dealing with the willing buyer, willing seller. The IRS came in and they, of course, focused on the ultimate purchase price and kind of ignored all the other offers. The long and the short is they did do the post-sale analysis, but the benefit, because of our 15% marketability discount on the risk related to the deal, they allowed us to take that, which in a sale, at 40 million was not a bad outcome, but the facts were crazy. And I've been involved in other situations where you got really sophisticated big investment banks, making offers for a particular company, and then somebody comes in and offers twice as much, and you got to wonder, in these cases, where is the willing buyer, willing seller? What's the market participants, as they say in fair value, is down at that 350 or 400 million, and then this unique strategic person. So the argument is really, is it reasonable to take such unusually different transaction values and ascribe it to a date of death or a gift when it could not be forecasted? Now here in this case, the offers were on the table. The offers were known and on the table, so there isn't much you can do. But there is a real mismatch as to being able to look at stuff when the price that got paid was so crazy beyond what the market would have justified.
One of the things, just as a comment before we go on, and we've all seen this in practice, and it's just very difficult. And maybe, again, we don't have the real facts, the backstory here, but, in a lot of cases, we've all had clients that we talk to about planning for years and years and years, and they don't want to do anything. And why don't they want to do anything? Well, I'm not sure I'm selling the company. And they don't want to incur the legal fees of transferring part of the business to a trust and setting up a complex trust unless they have a deal going. But so by trying to save the money and avoid doing the planning, they end up waiting until they do have a deal, and then you end up with the problems like in the CCA. You know, clients need to plan proactively. You have a valuable growing business. Don't wait for there to be even a cloud on the horizon of a realization event. Clients need to move faster, and that's really, really significant. Scott or Jonathan, on slide 23, do either of you want to comment about post-valuation date events in general?
Well, let me comment about your comment. It's very good to do the planning before there's a deal, but I will say that we end up seeing situations where not only have they actually started shopping the business, but they've signed a deal with a SPAC, and then 5 days later they're doing a transaction at 1/3 the value of the SPAC in a gift, and then we've seen transactions. A SPAC, you have to de-SPAC. You sign a deal, an agreement to merge with the SPAC, and then ultimately you have to effect the merger, which is called de-SPACing, where there could be a whole different value than the one that's the pricing on this publicly traded SPAC is implying at the time the deal is signed. But the to having gifts being made when the deal is closed, but the CEOs have not even met, and there's still due diligence being done, and there is a risk that a deal could crater. And so we work with clients, and they have to understand that the discounts become smaller. It's almost like an arbitrage analysis. What's the probability the deal will close versus not? And that's the way we look at it. So what I'm saying is that even though the clients wait until they're in some form of a transaction, there's still material savings that may be available, in the making, and that they shouldn't just write it all off and assume that it's gonna end up. And especially in these days where they end up taking back stock. If a private equity firm or somebody buys a company of any material size, the seller usually has to take back 10, 15, or 20% of of that company's stock. So those are there's some real interesting aspects that can aspects to discounting for those kind of situations. So it's not a lost cause, it's just a lower discounts, that's all.
I think we've covered kind of that. Is there anything more you want to comment, Scott, about how you evaluate the likelihood of a deal? We've kind of talked about it, but it seems to me if there's still due diligence to be done, if there's preconditions to closing, don't you go through and evaluate those? And it's very fact sensitive, deal specific as to whether or not.
Oh yeah, yes, that's exactly what when I was referring to the Florida thing. We looked at all the issues that had to yet happen. We looked at the form of the payment. We looked at the financing, and the impact that deal might have on a potential buyer. Because if it's going to be 80% of the buyer's new assets is one thing versus 10% of the assets of the buyer, if there's seller financing or anything like that. So yeah, we looked at as much of the detail in the deal as we could, and took a jaundiced eye towards what as a buyer would. There's the seller who has the information, and we hope that they'll share it with us when we're doing the valuation. And then but we also put our buyer's hat on, who's going to push back on some of the maybe unreasonable aspects or assumptions that the seller is trying to give them. So anyway, we look at all the process, and in fact sometimes people get caught too. You have board meeting minutes, and the IRS goes and audits. They go and require to see them, and the appraisers probably should do that as well, especially if it involves any kind of transaction, because if they're talking about it at the board level, you know, at any point during the valuation process, and it's serious, you know, the appraiser should know about it because it's going to catch, you know, it's going to bite them in the butt later on.
One of the factors that seemed a little unusual in the CCA, we've all had clients that have signed documentation, you know, maybe it goes beyond the memo of understanding or LOI and it goes to, you know, a contract while they're doing due diligence, but there's still lots of outs. And in this case, the IRS and the CCA said it was practically certain that the merger would go through. One of the things that struck me, which I've not seen in practice, we've all had lots of deals where, you know, we've been at different phases on that continuum, but here they had 5 companies initially, and I think near the end there were still 4 contenders. So, Scott, might it be in part that, you know, if you have one potential offer or buyer and there's contingencies and due diligence, it's a little different of an evaluation than when you have 4 people in the running, where it kind of makes it look like if one's not going to buy it, somebody else certainly will. Would that affect how you would evaluate it?
Yeah, I think it would. I mean, we would do a, you know, a likely deal value and a no deal value. And if you have one buyer, you know, then it's kind of a on or off situation, right? You buy or you don't, as opposed to having 4 offers. And it depends on, you know, where those offers sit relative to each other. But yes, the probability of a deal is, I think, going to be higher, you know, where you've got multiple buyers than it is where you've only got one buyer. And again, that probability, I mean, you see, if you think about arbitrage in the public market where deals are announced and, you know, a deal is at $8, but the stock trades at 7, you know, then there's a fairly big arbitrage there going on, saying that there's a full dollar's worth of risk that thing is going to actually close, and it's publicly announced. And then as you get closer and closer to the actual closing of that transaction, those prices will move together, and there's no longer an arbitrage. So we look at it as an arbitrage. What's the risk of that deal closing? And that, I think, you know, without, I mean, if it's on the day, the eve of the closing, it's a problem. I mean, we've done gifting where, you know, you had an IPO and it was the day before the IPO, and the question was, would the trustee, you know, be contributing stock into the IPO, you know? And there's, you know, what's the risk of that? And, you know, so you take the facts and circumstances into account, and you know, put together the most logical and justifiable report. You know, it does everybody good to do that, you know, in the long run.
So, Jonathan, one of the key things in the CCA that we need to talk about is the qualified annuity and the GRAT. And I don't think we need to talk about all the other requirements, because really the key issue came down to, was the annuity qualified? Annuity is stated in terms of a fraction or percentage of the initial fair market value of the property. And here, what they claimed in the CCA is that the value of the annuity, the value of the property, was so misstated that the annuity itself wasn't qualified. And that's how they in effect blew up the entire transaction, not merely made a valuation adjustment that would result in an adjustment of the annuity amount. You want to comment on that? And maybe we should talk also about Atkinson too.
Well, this leads us into Atkinson. I mean, Atkinson was a case where someone created a charitable remainder annuity trust, and she died, and it was included in her estate. And the people who were going to succeed her as the annuitants couldn't make up their minds as to whether or not they wanted to take it or not. But the IRS basically came in and said, well, it doesn't matter because we're going to give you no charitable deduction whatsoever. And the reason they said was that it failed to function as a charitable remainder trust. I mean, the trust, the court admits, the trust was a perfect trust on paper. And in fact, as everyone knows, the IRS has issued forms, and they guarantee if you follow those forms, you will have a proper charitable remainder trust. But one of the things that's in the regulations, and we've quoted it here, is that the charitable remainder trust not only must meet the definition of a charitable remainder trust, it must function exclusively as a charitable remainder trust from its beginning. And the IRS took the position that the woman who created this, Mrs. Atkinson, never received any of the annuity payments. So they said it didn't function as a charitable remainder trust. Now, the backstory is that the lawyers who were involved with this actually went to her home after she died, and they found a shoebox filled with uncashed checks, including the checks that the trustee had sent her year after year. She just hadn't bothered to cash them. But the judge didn't allow them to put in that evidence, and when you read the 11th Circuit decision, it says, well, they never proved that she got these payments, which is most unfortunate. That is not the same for a GRAT. There's nothing in the GRAT regulation which says it has to function exclusively as a GRAT. But the CCA says we're going to come after you. Now, they have the one thing: you have to make the payment within 105 days of the close of the year. So if you're supposed to pay out $25,000 or $25 million each year from your GRAT, you have 105 days to do it. And I've been involved in a couple of circumstances where it was not paid in that 105-day period, and the IRS has taken the position it failed from inception, using basically the Atkinson theory that it has to function in the manner in which you said it would. Now, again, I think in Atkinson it was unfair because the woman had been sent the checks. She just hadn't cashed them. I don't know that that's anybody's fault. But here they said, because you were so far off in value, you didn't come close to paying the proper annuity, and therefore you fail from inception. I'm confident this thing, unless it's settled, will go to court, and the court will decide whether or not they're going to have an Atkinson-type rule that if you fail to follow it perfectly, it's bad. And the IRS might argue, well, and in fact, remember in the GRAT regulations, they state, if there is a mistake in valuation, you can go ahead and correct it, just as you can in a charitable remainder trust. Unlike the Atkinson case where they claimed there was never an annuity paid, here it was they claimed you paid the wrong annuity. And I'm not sure the courts are going to follow that, but I don't think anybody can take the risk of that.
So let me ask you a question that you probably can't answer, but I'd like you to try anyhow, because I think it's, as they say, the $64,000 question. So in this case, in the CCA, I think the valuation differential was threefold. It was very significant. But how much is too much? If a GRAT is off by 50%, by 100%, how much off does the value have to be before you move from, okay, it's a valuation error, and we're going to adjust the annuity payment under the regs, right? Because it's stated as a percentage of the value of the property, versus the IRS blowing it up as they did here on the basis that it doesn't qualify.
Well, Marty, of course,
how much is too much?
We don't know, but I know the IRS was angry. The government was angry because it felt they had tried to hoodwink them by using a value which they knew wasn't close to what it was really worth. I mean, you're never going to see a work of art go into a GRAT, but you might see a piece of land, you might see business interests, and you got to have a proper appraisal. And because you can make the value of a GRAT so low, why not use the proper valuation? I mean, that's the best thing you can do. Because otherwise, you can bet your bottom dollar. Marty mentioned this earlier today. The IRS is now going to start looking carefully at GRATs that are funded with non-marketable securities in hopes that they can find out that you didn't pay anywhere near the proper annuity, and therefore they're going to claim that, you know, you acted in bad faith, and therefore you have a bad GRAT, and the whole thing is subject to gift tax.
See, so we're kind of like in the same situation after a Powell or a Cahill, where you have a case that, we look at and say, well, this is kind of extreme. This shouldn't affect me. But how do you know? How far off can we be? And this is a rhetorical question before the IRS goes from just an audit adjustment to undermining, torpedoing the entire GRAT. And this is now a risk I think we have to apprise clients because I don't think we have a bright line.
Well, I think, Marty, going back to what Scott has been talking about, if you disclose everything to the appraiser and the appraiser has it in its report, then I think the chances of the IRS making an argument as they did here in the CCA, I don't think it's going to arise. They may come up and say, we violently disagree, but all the facts are there. Then it is just a valuation mistake. I think this was, you're trying too hard to hide the ball.
I agree.
But
I agree.
We'll see.
But we still have to be careful and caution clients because we don't know.
That's correct.
So now I have another question, Jonathan. Let's assume the IRS has now clearly taken an Atkinson rationale and applied it to a GRAT, which is something that we've speculated about before. And I vaguely remember some practitioners saying that they've actually had that come up on audit. Are we going to expect more Atkinson type arguments on GRATs? Are we going to expect more? Should we expect more GRATs being attacked because the formalities were not adhered to?
Well, Marty, I think let me tell you, I think we may have this at a later slide. As I mentioned, the regulations say you have to pay the annuity from the GRAT within 105 days of the close of the year. And I was hired as counsel to a family where they had not made the payments at all, theoretically. Now, I had to go to my house of worship and ask for forgiveness for kind of misleading the IRS, but they gave me a 90% concession on it. But the bottom line is that they have taken the position in audit, if you don't pay the annuity within 105 days, then you have a bad GRAT. It's just you've not done it, and therefore it's bad from inception, just like Atkinson was bad from inception. You've got to make sure the annuity was paid on time. In fact, after I handled that case, when I would do a GRAT, I would send a letter to the client saying, we are not responsible to make sure that this GRAT is properly administered, including making sure the payments are made within 105 days of the close of the year. If you want us to, you will have to separately engage us to do it. And by the way, I checked with 5 clients who had appointed individuals as their trustee of the GRATs. Guess what percentage of that 5 had actually paid the annuity within 105 days? It was 0.
Don't say it. Don't say it.
Not one of them had paid it on time. So that's something, again, your client isn't going to care that you warned them. You've got to make sure you have in writing. We are not going to be responsible to make sure that the trustee properly administers this GRATs and the payments are made on time. And that's a very, very serious matter. And I think between the 105-day payment rule and the requirement that you actually have, a good appraisal, kind of like, happened in this CCA, is how the IRS is going to try to make money. Now, Diana Zadel and I mentioned before we did this study comparing GRATs to installment sales to grantor trust to outright gifts. But what Diana and I did was to come up with some language to try to save your bacon if it's not paid within 105 days. In fact, it's in the, I'm proselytizing now, but it's in the ILS documents. And I've gone through it with a number of what I regard the most outstanding attorneys in the country, and they all agree it's a great idea. Because no matter what you say, no matter how they promise, somebody is going to mess up and not make the payment within 105 days. So you need that kind of language in your instrument to try to keep it together.
So our final segment, which should be very quick because we've really kind of covered it, but I think it's worth just mentioning each of these. And we do have one new point that I want to make, is what are some of the ripple effects? What are some of the planning implications of all this? So one of the things that I do in practice, I don't know if anyone else does it, and you all may feel that I'm a little overboard, and that's fine. We have sort of a risk factor checklist that we send to clients on larger or more complex transactions. And my theory concept, what I patterned this after, is when I started in the practice long, long ago, before I had gray, I did a lot of private placement memorandums, which, you know, tax shelters, whatever you call them. And the first thing that I did in every PPM was to draft a risk factor section. And my instructions as a young lad in the law was think of anything possible that could go wrong and put it in there as a risk factor. So I kind of used that sort of approach and created a series of risk factors that we send out to clients, and we try to tailor it so that it reflects their transactions. I've already added to the template that we use that we then modify for clients, the valuation issue and the GRAT issue, because I don't want somebody to come back and, oh, you didn't tell me. You didn't tell me. No, I did tell you. It's in the memo that you got. Now, I guess one question we've already talked about, so I'll just state it unless Jonathan or Scott have comments, is I think going forward in terms of GRATs, we may see an extension of the Atkinson form of attack. And it's critical that we encourage clients to have annual review meetings with all their advisors and that they really take seriously the administration of their GRATs. I think it may be no accident that Smaldino and the CCA came out in short order. The IRS, as Jonathan suggested, is looking for money, and boy, maybe it's a lot easier and more efficient to look for clients that aren't administering their plans properly, because it's kind of an easier argument. You didn't do it. You didn't do it according to what the documents say or according to what the regs say or the law says. We don't have to get into all kinds of detail. It just, you didn't do it right. So I think we should expect more of that. Now, here's a point that Jonathan and I need to talk about for a minute, because I think it's important. So there's lots of different ways you can do a defined value clause. You can do a king price adjustment. I sell $10 million stock for $10 million. If the IRS adjusts the value, you can adjust the face value of the note, and therefore there should be no gift. King 10th Circuit case. Another approach is the Wandry clause, that approach based on the Wandry case that many people use. I'm selling or giving $10 million worth of LLC interest to this trust. So I think it's worth, and for administrative convenience, we're going to treat it as if it's worth 50%, because that's what the appraisal said. But I'm not selling 50% or giving 50%. I'm giving or selling the $10 million worth of interest. So if the IRS comes in and says, Marty, the valuation is wrong. We didn't use Empire. We used brand X trust, appraisal firm, and the value is off by half. It's really 20 million, not 10 million. Well, no problem. I only transferred 10 million, so we only really worth of LLC interest. So I transferred 25% instead of the intended 50%. There's another class of defined value mechanisms, and I think it's based on like Petter and Christensen, where I'm transferring my 10 million by sale or gift to a trust, but I'm getting rid of all the interests that are intended, the full 50%. If there's an excess value, I'm not retaining it. It's not that I haven't transferred it. I'm transferring everything. The excess could spill over to a donor advised fund, but you may have UBIT issues. The excess could spill over to a GRAT, which is very commonly used, or it could spill over to an incomplete gift trust, or even a marital trust, but that raises different issues beyond what we're talking about. So it's been very common to see people have their spillover mechanism where their fixed dollar amount goes to, say, a Grantor trust, and the excess pours into an incomplete gift trust or a GRAT. Now, there are some very smart practitioners who have told me that they really prefer the incomplete gift trust. I think Jonathan's in that camp. There's a lot of other very smart practitioners who have said to me that they prefer the GRAT for a spillover mechanism because the regulations define a GRAT, and if you adhere to them, you win, and an incomplete gift trust may be less clear. Jonathan, does this CCA change that analysis? Might we want to start considering using, if we had been using GRATs for the spillover, might we want to reconsider and use an incomplete gift trust? And the reason I ask the question is that GRAT is only really getting substantive funding. Maybe I put some money in it up front at the transaction date, so it's a functioning GRAT, but the real value would only go into the GRAT if there's a valuation adjustment. And if there's a valuation adjustment, doesn't that raise the specter of the CCA? What do you think?
Well, Marty, I think there are a couple of things. Number one, you can have your GRAT all set up and say if there's an excess value, it's going to go to this GRAT. In other words, you say you have a transaction. You're not doing a GRAT. You're making an installment sale to a grantor trust, or you're making a gift to a trust. It's not a GRAT, but you say if there's any excess above, pick a number, $5 million, $10 million, that excess is going to go over to the GRAT. Well, you already have the GRAT in place. The problem is that you can't make additions to a GRAT. That's prohibited. In fact, your instrument must prohibit additions. Well, you might argue, well, I really didn't make an addition. I just said whatever the excess is goes. But I think you're now in the same kind of situation that the poor people with the CCA found. You may be so off in valuation that the IRS is going to say you have a bad GRAT from inception, and you will not have paid the proper amount within 105 days. It will be a real problem. I like, maybe, it's because it was invented here, I like the incomplete gift trust, where basically you say, okay, I'm transferring $10 million to this trust from my son, and I'm transferring any excess over to a trust of which I have such control that if there is a gift to it, it's incomplete. And I think that I've always felt that that's, more protective than doing something like a GRAT. Because of the specific requirements of the GRAT, and now we have the CCA, which is really pretty scary.
So just to summarize the ripple effects, first, we have to think of the potential risk of more Atkinson type attacks on GRATs in general. Second, what we just talked about, I think we have to rethink the use of GRATs and defined value mechanisms, or at least apprise the clients of the additional risk. And the final thing, which, Scott, unless you have final comments, I think we've talked about it in pretty significant detail, is we really need to make sure clients understand the valuation issues that were raised in the CCA. And I don't think we can rely on just the fact that it was four offers or 5 offers or a 300% increase. I think we need to be much more careful because we don't know where the line will be drawn. So we need to be, I think, more mindful of what happens in valuations. Scott, any final comments on that?
No, I think it's a matter of, being above board, talking about what's going on. I mean, and we found, in situations where there are transactions where we've actually been able to, but it was our efforts to talk to the bankers and get information on where they thought things were going. And really, looking at what is there and, making the best use of it, and disclosing it, I think is the best way to do it. And you reduce the risk. You might increase the cost relative to value, but at the same time, that's going to depend on where in the process it all is.
So I think we've really taken what was not that long of a CCA and given hopefully all of you a lot of practical advice and a pretty detailed analysis of not only the CCA, but a lot of the planning ramifications, especially on valuation issues, on Atkinson, on defined value mechanisms generally, which go well beyond just the face of the CCA. I want to thank Jonathan Blattmacher and Scott Naumacher for joining me. You guys were great. It was very helpful. I want to thank Interactive Legal and Peak Trust, our sponsors. And a last shout out to Michael J. Fox Foundation for Parkinson Research, which is the charity that we featured in this program. And I encourage all of you to reach out to the Fox Foundation and see if you can do anything to help them. It's a great cause and a great organization. Thank you all for joining us, and good luck.
And thank you.